Inheritance and divorce in Florida. Dividing property in a Florida divorce can be complex, especially when one spouse receives an inheritance. Understanding how the law treats inherited assets is essential to protecting your rights and financial future. Florida law distinguishes between marital and non-marital property. Marital assets are generally divided equally, while non-marital assets are retained by the original owner. According to Florida Statute 61.075, an inheritance is classified as a non-marital asset. This means that if you receive property or money through a bequest, such as, "to my loving daughter," that inheritance belongs solely to you in the divorce, not your spouse. Even if you sell that inherited item and buy something new, the new purchase remains a non-marital asset, as long as the funds can be traced directly back to the inheritance. However, to keep an inheritance from being divided, you must prove that the property was inherited. Florida law presumes that all assets acquired during the marriage are marital unless proven otherwise. That's why detailed documentation is critical. You'll need clear financial records showing the source of the inheritance and its separation from other joint assets. In some cases, inherited property can become marital property. This happens if you add your spouse's name to the asset, mix it with jointly owned funds, or treat it as a gift to the marriage. Florida courts analyze whether the conduct during the marriage suggests you intended the asset to become shared property. If, for example, you deposit inherited money into a joint account and spend it jointly, it may no longer be protected as non-marital. While inheritances are not split in divorce, they can still influence other divorce outcomes, particularly alimony. Under Florida Statute 61.08, courts use a two-part test to decide on alimony: whether one spouse needs support and whether the other can pay. In doing so, judges can consider both marital and non-marital assets. That means your inheritance, even though it's not divided, could make you appear financially capable of paying alimony. That said, lifestyle matters. If you don't immediately change your spending habits after receiving an inheritance, and a divorce happens soon after, courts may base alimony decisions on your previous standard of living. In some cases, this can minimize the impact of the inheritance on alimony obligations. The process of protecting an inheritance begins with clarity and documentation. If you receive a gift from family or get your inheritance early, the law still treats it as non-marital property under Florida Statute 61.075. However, the moment you combine it with marital funds or title it jointly, you risk it becoming marital property. Courts look at your intent and how the funds were handled throughout the marriage to make their decision. Keeping an inheritance separate can be complicated, especially during emotional times like a divorce. An attorney can help you gather financial records, structure asset ownership, and argue your case effectively in court. A lawyer can also assist you in defending your rights if your spouse claims that a gift or inheritance was intended for both of you. To protect what's yours during a divorce, work closely with a law firm that understands how Florida law treats inherited property. Every detail, from how assets are titled to how they're used, can affect whether you keep them or must divide them. For help with protecting inherited assets or navigating alimony concerns, contact the law office of Russell Knight at 239-202-0455 or visit the office at 1415 Panther Lane, number 218, Naples, Florida, 34109, United States.